2002. I slept on the evening, it was a Thursday, and I was feeling unwell. And I heard at midnight there was a press conference. But in the morning when I was driving to work, one of the newspapers carried an article. Well, they have the headlines. It was written, "Judge demoted." And as I was driving through, I said, "Oh, I wonder who that is." And then I got to court. I was sitting in a habeas corpus matter with the Chief Justice. And then when I got there, well, I got to learn that I was the demotee in this matter. So when the case started, the one who was representing the government in that case gave me a copy of the government gazette by which I had been transferred from the High Court to the Industrial Court. I did not apply for that transfer. So I resisted the transfer, and for a period, they said I must speak slow. Oh, let's closer, thank you. So I was, for a period of 7 months, I went to work and I was not given any work in the High Court. And I made sure that on every working day, I did not abscond in case I was then dismissed for being away on duty. So fortunately, the term or the tenure of the Prime Minister, who was responsible for my removal, and who was a client of mine, by the way, I was instructed in a case where his political career was hanging on a bare thread, and it was repaired. He remained in office. But when it suited him politically to discard me, that is what he did. So fortunately, I went back to the High Court. And then in 2010, after my tenure in Botswana, I returned to Swaziland. And one of the most unfortunate things that may happen is when judicial leaders become the persecutor of the members of the judiciary. And unfortunately, the Chief Justice, for some reason, saw me as a threat and then aligned with the political elite in order to engineer my removal as a judge of the High Court. As was stated, I faced 12 counts. And this is one of the, longest number of counts, even when I was doing criminal cases that I had to deal with. I was a very bad judge, 12. One of them was that I had an illicit affair with a colleague. I did not. But even if I did, I was not in the position of Hermoso and Rubiales. I hope I'm not losing you. But anyway, besides that, and then there was a charge that I was associating with people who want to unlawfully change the regime, and that I had given permission to a member of staff to go on a trip without the Chief Justice's knowledge. So all those 12 counts. I was represented by very able counsel. There is one top South African senior counsel, Mr. Wim Trengove, SC, his junior was Mr. Skakane. So one of the issues, the first issue we raised was the impartiality of the Chief Justice, and that has been dealt with. And then the other thing that happened was on the eve of the hearing, I was served with an unsigned affidavit by the registrar of the High Court, who happens to be a former student of mine. He was the one who was carrying the persecuting instrument. So the affidavit was unsigned. My counsel advised that I should prepare an answering affidavit dealing with the allegations that he made, on the basis of which I was supposed to be found guilty. On the morning of the hearing, that is when we were given a signed copy of the affidavit. Then my counsel started by asking the Chief Justice to recuse himself, and he refused. We then got an adjournment, And then during the adjournment, he told me, Judge, you have two options. One, it is clear where this thing is headed to, so you can walk out. The second is that you stay on, and in my assessment, there's going to be a number of irregularities that are going to be committed during the hearing. So I chose the latter. So when we returned, he then says to the Chief Justice, you have two phones before you, referring to the affidavits, one by the registrar and one by the judge. Which one are you going to believe? Is it Roman or Ariel? I'm just making an example. So he says, we're asking for leave to cross-examine the registrar. That was refused. So no evidence was led, and then I was found guilty as charged. In all the criminal cases that I have held, I always truncate the proceedings. There is the finding of guilty, where I say you are found guilty of this offense. And then there is the sentencing part, where a mitigation process is undertaken. The person says why he should not be given a lengthy sentence, and the state argues otherwise. For me, it was a once and for all. After being found guilty, I was dismissed. I was not even given an opportunity to address and state maybe what good record I had, how many judgments I had written, and so forth. That became naught. So that was the end of my judicial career. Then in 2014, I applied for a job as ombudsman for non-bank financial services in Swaziland. I went for an interview. It did not come from heaven. I went for an interview, psychometric test was carried out, and I came out with flying colors, even if I say so. That's what my Chief Justice, the one who persecuted me, let his soul rest in peace. That's what he used to say, even if I say so myself. So I got a contract for a period of 5 years, which was renewable. After 1 month and 5 days, my contract was terminated. No reasons were given. So I had my parents, and then I say, but what do I tell them? What do I say to them? Because they're going to say, there must be something wrong with you. Just a few years ago, you told us you were in the clear, you were dismissed. That was for a long time. Now, only 1 month and 5 days, and you are dismissed again. There must be something wrong with you. So fortunately, as Providence has it, just before before long, I then got a call from the Chief Justice of Namibia, and he said, there's a case that he would like you to do, and the rest is history. So indeed, I am a victim. So in this case, there were 3 instances, and there were cases that I dealt with. One of them was where the Commissioner of Police violated an order of court, and I ordered that he must be, he must be committed to gaol for doing so. He never saw the inside of gaol. So all these are cases that raise my profile to fever pitch in the eyes of the authorities, and they had to get rid of me by all means, foul or fair. Now, after the case, okay, let me start here. After my dismissal or my removal, my counsel, Mr. Trengove, said, Judge, let us take the issue on review before the High Court. I spoke to my instructing counsel. He said, Judge, that we cannot do. Do not sanitize this process by going through a process over which the Chief Justice is actively in charge. You are going to go to the High Court, seek a review of the proceedings, and the Chief Justice will allocate a judge, and you'll be found to be on the wrong side and your application for review is going to be dismissed. And then you go to the Supreme Court where the Chief Justice sits. He said previously he might sit again. Even if he does not sit, he's actively in charge of the Supreme Court. So he said, I advise you not to go through the local process because the result is a foregone conclusion. Then where do I go? I look at the SADC tribunal. It is taken away. Its human rights jurisdiction is taken away, and there is no SADC tribunal. I want to thank members of the civil society, including the Law Society of Swaziland, Lawyers for Human Rights, Southern African Litigation Center, the International Commission of Jurists, amongst others, who then said, let us go to the African Commission. So that is where I ended up, because I would never get justice in Swaziland, where I had been seen to be an enemy of the king and the Chief Justice. So I would never get justice in that country. So that is how my matter ended up before the African Commission. How did it go? In April last year, it was a Friday, I saw that there is they call it a nota verbal. I'm not in the diplomatic circles, but overnight, I received a copy of the decision. I have written hundreds of judgments in my 24-year career as a judge, but I never knew the tension that attaches to reading a judgment where you are the litigant, particularly the victim, as I was. So I decided not to look at the end, at the finding, and I went through all the emotions. It looks like there was a lapse on our side in not following the rules, and the case was almost kicked out. I was there picking it up as I read, and then I found that condonation was granted. The matter went on to the merits, and then finally, I read that my article, I think they've been mentioned, my article, is it 726, rights had been violated. It was 1, 7, and 26. And I was elated. But there are a few things that happened. Even with the salary of a judge, I could not afford to litigate before the African Commission. One, there is a matter of distance. Two, there is a matter of cost associated, because the legal practitioners have to go there. So these are some of the things that we need to think about. There are so many people in Africa who do not have the privilege that I had to have people in their corner to stand with them, probably because my case gained prominence and maybe by virtue of the position. But there are so many people whose cases might be worse than mine, but because of impecuniosity, they do not have the wherewithal to bring their cases before the commission. So the issue of access, the commission is there, but can you get there? That is one issue. I was fortunate. Secondly, one of the prayers that was sought by my legal team was that I be reinstated unconditionally. But as matters went, the case was lodged in 2013, and judgment or the decision was only delivered in 2022. That is 9 years later. If an order for my reinstatement had been issued, the government would have had the easiest reasons to give to say, we have an establishment register of judges. We have so many. Judge Masugu does not have a post. There is nothing we can do on account of the length of time this matter has taken. And it is not just a matter of time, also the emotions that you go through in this lengthy, I will call it, gestation period, awaiting an outcome. So maybe something needs to be done. I do not know about the length on average cases before the commission take. Maybe mine was one of the longest because of hiccups here and there, but I think something needs to be done. Those who know say justice delayed, maybe is justice denied. But the Chief Justice of Zambia, Mr. Chief Justice Sakala, also adds and says, justice hurried may be justice buried. So there must be a balance that is struck. I was happy at the end of the day to learn that I must be compensated fairly. I think it was two phrases that were used. It was fairly, is it justly as well, one of the two. I am still waiting. And equitably, I am still waiting. One thing that I would probably suggest, the decision, I will call it the order of the commission, does not state who must determine the compensation. Is it the commission? Must I go back to Swaziland, where I ran away from? Who must give this order for compensation? That is an issue. And then a side issue. What I would propose is that in some of these matters, particularly where it comes to compensation, if it is the commission that will deal with the compensation, is there anything wrong with dealing with both the merits and the damages at once? Particularly because some of these matters take long. So if I have to go back to the commission, I'm now going to start another chapter of the determination of the compensation. In Namibia, and I'm sure in some other jurisdictions as well, when you deal with matters involving damages, it might be defamation or whatever, you deal both with the merits and the compensation. Evidence is given as to what your loss was, so that when the court reserves judgment, it reserves judgment on the entire matter. At the end of the day, you get, yes, the court fines for you, and the compensation is also there. I do not know the rules of the commission very well. It might well be that there is something that maybe prohibits that, but I think in terms of time, in terms of costs, and also in just terms of completion, a one-stop process might be one that would be favored. I also, as I say, I do not know the procedures in the commission, but I want to make examples from Namibia. In Namibia, one of the things that happens in civil matters is that we have a case management system. The pace at which litigation is conducted is not in the hands of the litigants. It is in the hands of the court. So once a case is defended, the court takes charge. It will issue an order to the parties, defendant, you file your papers on this day, you replicate on this day, and then the matter comes for case management, so that there is no unnecessary delays that are caused by the parties to the proceedings. And coupled with that is a very strong sanction regime where the court exercises discipline over the parties and their lawyers for those cases where there is delay or non-compliance with court orders. Because otherwise, if there is no sanction mechanism, cases can take forever. As I say in my case, I did see that there were lapses on our part, which resulted in applications for condonation. But if there would be a stricter handling of the matters with the commission in charge, issuing orders for parties to comply and sanctions where there is non-compliance, that might work. Another thing that I would probably recommend, and I'm not an expert on this, is that, and I would want to draw the experience of Namibia, we have a very strong alternative dispute resolution mechanism, which is in the rules. There are certain cases where it is compulsory for them to be submitted to alternative dispute resolution. I make an example of matrimonial matters, divorce, damages, defamation. All those cases must compulsorily go through a mediation process. And the experience previously has been that about 67% of those matters settled. And that is a big chunk that is taken away from the court's role. But when they do not settle, they then go on. The important thing here is that the alternative dispute resolution is not done by the judges themselves. They are trained mediators. So I'm suggesting that maybe something like that could be done, because you might find that there are cases which can settle where there is a compulsory process rather than where it is in the choice of the parties. It can be a question for the commission to decide at what stage that can be done, because there are some cases which can settle with only the plaintiff having filed papers, the defendant having filed nothing. But there are also those cases where you'll find that once the parties have all filed their papers and the defendant sees that the plaintiff's case is good, then maybe we should settle. So that can be a matter of choice as to at what stage, but maybe some alternative dispute resolution mechanism might assist in getting matters through quicker than would otherwise be the case. Then maybe lastly, is that I want to applaud the commission for the work that it does. There is no system that is perfect. But when one reads some of the cases and the jurisprudence that emanates from the commission, I think an applause is really necessary. But then at the same time, I think there should be more interaction with local jurisdictions. Many of the jurisdictions do not know about the African Commission, including lawyers. Some of them do not know how the commission operates. They do not know what the procedures are. So I think there must be some kind of outreach or communication with the various law societies, because countries where everything is stable will find no need for the African Commission until things start going south. And there is no guarantee that at some stage things might go south. So my victims' status ends here. Thank you for your attention.
Thank you very much, Judge Masuku, for that comprehensive explanation of your victim status, but also your own interaction with the commission and the experiences that you've shared with us. Our respondent from the side of the commission is Ms. Irene Mbengwe, who is a senior legal officer at the Secretariat of the African Commission. And Justice Masuku has raised at least 5 pertinent issues that potentially the respondent could provide some clarity on: access, cost involved in the ability to access the protective mandate of the commission. I mean, being a litigant before the commission, I might have different views of how to navigate this process without that much cost, because most of the commission's processes are actually, they does not require physical presence, but I would like the commission to provide specific response to how this actually works in practice, but also the length of time that it took for the case to be dispensed with. When I read the case, I actually noticed that the pleadings seemed to have settled in 2017, but it took about 5 years for the actual decision to be reached by the commission. So what could also be some of the impediments that the commission is facing, and how might other stakeholders be able to assist in that regard? And then there was the issue of the compensation, and where in the instance where the commission leaves the question open to determination, who exactly is responsible for determining this compensation? And if the state, for instance, determined a compensation that the applicant is dissatisfied with, what then would be the next step in seeking redress for that particular, if you like, reparation that has been given by the commission? And then there was the issue of amicable settlement, and how often the commission is encouraging litigants to settle the dispute if it is a dispute that could easily be settled without having to wait for 9 years for a final determination, whose implementation sometimes is also, taking, many more years to get implemented. And then finally, on the issue of outreach and visibility of the African Commission. And I think we all recognize that it's a very big issue, that a lot of people on this continent have no idea of the Commission. Those who knows about the Commission have no idea how to access its processes. And it's actually quite dire, even among lawyers, that a lot of lawyers have no idea what the African Commission is and what it does and how to access its processes, and what specific measures are in place at the moment for the Commission to ensure that it's visible among the African populace, and in particular, as the judge had suggested, law associations, civil society organizations that are potentially the ones that are going to bring these kinds of communications before the commission. So I will hand over to Ms. Irene Mbengwe, who is joining us on the Zoom platform for her responses. Thank you very much.
Good afternoon, everyone. I can hear my echo. I'm not sure. Can you hear me well?
We can hear you clearly.
Okay. Thank you very much. And it's a pleasure to meet Justice Masuku himself, albeit virtually. And I'm sorry I can't turn on my video because we have power outage here and I might lose network. So thank you very much for that background. It's interesting to know how this case progressed and to be able to meet the victim himself. I'm sure he has admitted that he's a victim. So I'll start by responding to the issue of the delay. Then I'll flow towards the other issues that have been raised. And just to indicate that while to acknowledge that we do have internal capacity for processing communications, which are currently being addressed in staff shortages. I think in recent years, if you would notice, we have been able to get more communications out of our course list, and this is because we've been able to strategize on how best we can, finalize communications before the commission. So, but in this particular case, I would like to explain that the communication was delayed, first of all, because at some point, we did not receive submissions from the parties, from the complainant in particular, and therefore the communication was struck out for want of diligent prosecution. And then later on, we received information about a new legal representative who brought the communication back to who requested for a relisting of the communication. And this relisting was done, I think, in 2015. So apart from the internal issues that we had, the process-wise, there was also a delay in that regard. And in terms of the issue of compensation, I think this is something that the Commission has been battling with for a while. And recently, what we have adopted in some of the cases that we have decided in the past is that the determination of the compensation for redress, including legal, we'll notice that it depends on various factors, including legal framework, the nature of the violation, the relevant judicial and non-judicial processes, and the Commission's current practices to request domestic courts to assess the damages suffered by the victim. And the courts are required to consider the severity of the violation, the impact on the victim, and any economic or non-economic losses incurred. So the Commission is still discussing, a concrete way in which we can actually be able to compensate, to deal with the issues of compensation to the victims. And in the last session of the Commission, we had a discussion on a lengthy discussion on this, and we are trying to come up with guidelines for this process. In terms of legal aid, the cost of bringing communications before the Commission, I'd like to inform the participants that we do have, we're currently trying to get a legal framework together with the African Committee of Experts and also the court. We're trying to have a joint framework on legal aid. But in the meantime, what we've been doing is to advise the litigants to approach those. For instance, here in the Gambia, we have the Institute for Human Rights, where we always refer complainants to request for their assistance in processing their complaints from the seizure stage. In relation to sorry, I might have missed some of the questions. Amicable settlement. While the Commission does not specifically request complainant or the parties for an amicable settlement, we have it in our rules of procedure to initiate the proceedings, but we haven't actually at any point made that request to the parties to invite them for an amicable settlement. But in the event where we have a request from the parties, the Commission always engages through the country rapporteur to try to ensure that amicable settlement is done. And we've had situations, for instance, which are going to look at in this panel, that is Communication 341, where the special rapporteur on the rights of women engaged with the parties, both the state and the victim, as well as the legal representative, to come up with proposals for an amicable settlement. So I'm not sure if I've missed any of the questions. You were breaking at some point, so if I've missed anything, you could just remind me. Thank you.
Thank you very much for your intervention, Ms. Irene Mbengwe. Just perhaps one quick follow-up on the legal aid. And I know the African Court, for instance, has put together a list of lawyers that could potentially serve as legal aid counsel for applicants that appear before the court without counsel. Is this something that the Commission is exploring, adopting such a mechanism? Because I can tell you for a fact that for those of us at the litigants group, we have actually wondered why this kind of a system is not in place, because there are a lot of CSOs that actually wants to provide assistance to litigants that appear before the Commission that do not have legal counsel to support them. But it's not really clear what is the process to be able to assist applicants who do not have lawyers when they appear before the Commission. And just to follow up, if the Commission is thinking about having a similar mechanism in place as the court does, because the court compiles a list of lawyers who wants to offer legal aid services. And when cases come to the court, then they will reach out to the specific, individuals or organizations to ask if they are available to offer, such kind of services to those litigants. Perhaps if Irene, you can assist us on that, but then after that we will move.
Thank you. Yeah, so we are actually thinking about that, because we currently signed MOUs with the African Committee on the Rights and Welfare of the Child, and we already have an existing framework with the African Court, and we currently don't have that at the Commission. Maybe I should be clear about that. But we're trying to see how we can borrow from the court's practice to have one for the Commission. But broadly speaking, we're trying to have a joint legal framework where everybody can tap in from there and access the list of pro bono lawyers for their to deal with their cases. And while I was looking at my note, I noticed that I missed one of the issues that was raised about how we intend to build capacity, because most organizations or NGOs are not aware of the commission and even its procedure on communications. And just to indicate that maybe going back to the issue of implementation of this particular decision, that while we haven't received any information on the implementation and confirming from Justice Masuku that nothing has been done, would like to indicate that we had the Commission issued a resolution on the situation of human rights in the Kingdom of Swaziland. That was in May 2023. And in that resolution, even though it focused primarily on the killing of late Mr. Thulani Maseko and the release of political prisoners, it also broadly mentioned the failure of Eswatini to implement the decision of the Commission in specific communications, and also made recommendations on other aspects, including promotion mission reports, concluding observations, and so forth. And also to highlight that we do have a mechanism where we have special rapporteurs dealing with various countries. And it will be of interest to know that Honorable Commissioner Dr. Lita is a country rapporteur for Eswatini. And before she inherited the country, the former the former country rapporteur had indeed proposed a strategy for engagement, especially for following up on the cases that the Commission has decided against Eswatini. And I would just like to highlight some of the cases. For instance, we had Lawyers for Human Rights Council of Swaziland of 2008, where the Commission found that restrictions on public gatherings and demonstrations violated the right to freedom of expression and association. We also have the Thulani Maseko versus Swaziland case of 2015, where the Commission found the violation of the right to freedom of expression and fair trial. And then we have the Media Institute for Southern Africa versus Swaziland of 2018, where the Commission called for the repeal and amendment of certain laws regarding Terrorism Act and Sedition of Subversive Activities Act. And we also have the case of Likwa and others versus Swaziland. So these were cases that were compiled by the former country rapporteur to be able to follow up with Eswatini on the implementation of those cases. And recently, of course, we had to add the Justice Masuku case after it was adopted and published. That is in April 2022 when it was shared to the parties as one of the communications also that we had to make on a follow-up. But in terms of how we engage, I would just like to indicate that usually we do so when we have, for instance, promotion missions in the country. And one of the strategies that the former rapporteur had also meetings with civil society, government, to speak broadly on the need for a robust independent judiciary for the rule of law and human rights in Eswatini. So most of what we do is also advocacy in that regard. Thank you.
Thank you very much, Irene, for your intervention. I think I will hand over now to Dr. Victor Ayeni for some interventions on what we can take out as the most significant jurisprudential contributions of this particular communication to the issues that were discussed generally, but also to the vindication of the right to fair trial and the impartiality of courts in the African context. So,
I wanted to compliment Irene on some issues.
Yes, no, please.
OK. Merci beaucoup. Je vais donner certaines précisions sur les informations que Irene nous a passées. Je vois que vous avez besoin de mettre le... Je disais, je vais compléter l'intervention de Irene. D'abord, sur la question de l'assistance judiciaire. Nous avons obtenu l'autorisation de principe de la Commission pour travailler sur un mécanisme temporaire d'assistance judiciaire. Vous savez qu'au niveau de l'Union africaine, il y a un système d'assistance judiciaire pour tous les organes de l'Union africaine qui travaillent au niveau de la promotion et la protection des droits de l'homme. Mais ces mécanismes n'est pas encore opérationnel. En attendant ce mécanisme, chaque institution a créé un système temporaire. la Cour, le système de la Cour est temporaire. La Commission est aussi en train de travailler dans la création de son système temporaire en attendant l'opérationnalisation du système de l'Union africaine. Donc, la Commission a donné une autorisation. On est en train de travailler au niveau de l'opérationnalisation de ce mécanisme temporaire d'assistance judiciaire. La question de la lenteur dans la prise de décision, cette question a été partiellement résolue dans le nouveau règlement. Dans l'ancien règlement, il y avait 2 phases, ou 3 phases. Après la saisine, il y a l'échange d'écriture pour la décision sur la recevabilité. Après la décision sur la recevabilité, si la communication est déclarée recevable, on fait les échanges d'écriture pour la décision sur le fond. Avec le nouveau règlement, on a une seule échange d'écriture. Après la saisine, les parties font des soumissions sur la recevabilité et sur le fond en même temps. Ça qui va permettre que la Commission, après la décision sur la recevabilité, elle automatiquement passe au fond sans ouvrir la procédure d'échange d'écriture. Donc, ça va faciliter l'accélération de la prise de décision. Une autre mesure que la Commission a prise aussi pour accélérer la décision, c'est de catégoriser les communications. Il y a des communications qui requièrent un traitement urgent. Par exemple, votre cas, le droit au travail, ça ne peut pas prendre beaucoup de temps. Donc, il y a des communications qui vont bénéficier d'un traitement urgent, communications qui vont bénéficier d'un traitement prioritaire. Il y a des communications qui vont bénéficier d'un traitement, disons, ordinaire. Sur la question d'interaction avec les juridictions nationales et des ordres des avocats ou des barreaux en général, nous sommes en train de travailler dans un projet pour organiser la formation qui est adressée directement aux barreaux et dans le système anglophone, ce qu'ils appellent des law societies, de façon à permettre que la commission arrive aux juridictions nationales, au système national, à travers des avocats et des magistrats. Parce que on a constaté que la façon la plus efficace de disséminer les décisions de la commission, de disséminer la jurisprudence de la commission, ça doit être fait à travers des avocats et à travers des juges. Parce que ce sont des gens qui décident au niveau national. Donc, nous pensons que si on arrive à mobiliser les ressources nécessaires, l'année 2004 sera l'année que nous allons commencer à faire une deuxième formation parce que la commission a déjà organisé dans le passé une formation, une conférence avec des avocats et des magistrats. Donc, l'année 2004, si tout se passe bien, on aura une deuxième formation, une deuxième interaction avec le système judiciaire national. Merci beaucoup.
No, thank you very much, Pedro, for that intervention and for providing some clarity on some of the issues. I'll hand over now to Dr. Ayeni to make his intervention on the jurisprudential contribution of the communication.
Okay, thank you. First of all, I would like to appreciate the Commission for the decision because it's actually well researched. We have references to the previous jurisprudence of the Commission in several cases. But looking at the judgment or the decision, I'm able to pick out 3 areas that the Commission introduced substantial jurisprudence. The first one is in the area of striking out and relisting of communication. That appears to be a very new practice at the time. In terms of how the Commission approached it, and I believe that in the future, when a matter of this nature arises, there may be a need to refer back to the jurisprudence of the Commission in this case. So striking out and relisting of communication. Then the second area where I believe we have substantial jurisprudential contribution is in the area of calculating reasonable time when we do not have need when we do not have local remedies to be exhausted. Of course, the Commission has written substantially on exhaustion of local remedies in various decisions. But what is peculiar in this case is that the Commission, of course, agreed with the complainant that there was no need to exhaust local remedies because the remedies were not available. So it now became a problem. How do you calculate from when does the time start running in order to determine what will amount to a reasonable time? Because the communication was submitted longer than a year after the violation occurred. In fact, in the first submission of the complainant, in the submission on admissibility, they did not address the issue of reasonable time. So the Commission, they only addressed the issue of exhaustion of local remedies. So the Commission had to write back to the complainant to specifically address the Commission on the issue. So that's an area where the Commission equally made a very huge jurisprudential contribution. And then finally, we have substantial jurisprudential contribution on issues of fair trial, the right to appear before and be heard by an impartial, independent, and competent tribunals. So I'm going to just speak to each of these briefly, and then I'll make one or two suggestions. The first one is the novel procedure of striking out communications for want of diligent prosecution and the need for the Commission to temper justice with mercy. The last part is my own suggestion. According to the Commission, Rule 108 of its Rules of Procedure provides that once a communication has been declared admissible, the Commission shall set a period of 60 days for the complainant to submit observation on the merits. Rule 113 of the rules provides that when a deadline is fixed for a particular submission, either party may apply for the Commission to extend that period. So what happened in this case is that the complainant had 2 months within which, after the communication had been declared admissible, to make their submissions on the merits. 2 months was gone. There was no submission or no correspondence from the complainant. 4 months was gone, yet there was no correspondence from the complainant. So I think that when we look at it, the communication was declared admissible around August of 20. It was communicated to the party around August of 2014, the decision on admissibility. And then in August 2015, that's about 6 months, the communication was struck out. So because the complainant did not seek an extension of time within which to submit observations on the merits during the stipulated 2 months period and during the 4 months outside that period. So despite stipulating periods within which parties must present their written submission, the rules does not or do not expressly provide for striking out of communications for complainant's failure to diligently prosecute the complaint. It leaves it to the Commission's discretion. The power to strike out and release is a part of the inherent powers of the Commission. So here is my take on that. I said, the Commission declared the communication admissible in July 2014. The decision was communicated to the party on the 8th of August 2014. So at the time the Commission struck out the communication in February 2015, the complainant had neither submitted the merit submission nor confirmed the submission in the complaint that this Commission in the for the admissibility shall also apply for the merit consideration of the case. So accordingly, the communication was struck out for want of diligent prosecution. As a result of delays in transmitting to and for the Commission told the complainant, some of which are due to no fault of the complainant, the Commission in the future should temper justice with mercy, as some complainant may not be so lucky to get their communications relisted. On the other hand, I believe this approach is a wake-up call to complainants to take prosecution of their communications very seriously. So I just wanted to say that in my view, it would be good in the future that the commission should allow some more time because as we know, there might be some issues with respect to communication with the complainant. So that's like a suggestion that I want us to look into. So in this case, it was a gap of 6 months when the communication was struck out. Then the second issue that comes up from the decision is the extent to, that is the conversation about what amounts to a reasonable time. And I also suggest that I believe the conversation ought to have been taken a little further. The commission examined whether the communication was submitted within a reasonable time from the time local remedies were exhausted or from when the violation occurred pursuant to Article 56(6) of the African Charter. The commission stated that what constitutes a reasonable time is a question of both law and fact. Thus, the commission had previously heard that where 6 months appear to be the standard time limit applied by the Inter-American Commission and the European Court of Human Rights, each case for the African Commission is to be treated on its own merits. The commission notes that there elapsed a period of about 1 year from around February 2012, when the victim attempted to initiate domestic proceedings, to April 2013, when the complainant finally submitted the present communication. I don't know what we all feel, but this is just an idea, that the idea of a reasonable time or a standard time may have been taken a little further. I believe some standard time may be a welcome idea, like in the European human rights system where they have like a standard time of 6 months, and also in the Inter-American human rights system. And then anything outside the 6 month period can then be analyzed on a case, on the merit of each case to see whether it is reasonable or not. That is also an aspect that I also looked at from the decision. Then the other aspect, which has been alluded to by the victim now, is the fact that it took so long to arrive at the decision. The chair has also mentioned this, that the communication was submitted in April 2013, and it was finally decided in July 2021. That is a long time, more than 8 years or around 9 years. And like we were told, everything about the communication, we had all the information, the submissions of the parties were in as at 13th of December 2017. So it took a long time. And then I just wanted this like a cautionary note to all of us. I was trying to compare what happened here to the Nubian case, where a communication came to the African Commission in 2006. And then 3 years after, in 2009, that same issue went before the African Committee on the Rights and Welfare of the Child. And the African Committee issued a decision in 2011. That is less than 3 years. And then the decision of the commission in that same case came out in 2015 from 2006. So I feel this should be an area that internally the commission may look into. And I also want to advise that whoever is interested can commission a study to look into the time it takes at least the 3 African human rights bodies to arrive at their decisions, and then to look at whether the fact that the commission has a lot of cases to handle and so many other broad mandates, whether that could contribute to the elongation of the time it takes for the commission to render its decision. So I want to conclude with this, which is going to be the 4th point, that even though the parties reference the several decisions of the Human Rights Committee in their submissions, I did not observe that we had a number of references to those decisions. So I believe it is a good practice to encourage the various human rights bodies to talk to themselves. It's very important because it strengthens their jurisprudence. It also shows the parties that the issue being discussed is not an isolated issue. It's been addressed by the Human Rights Committee, the African Court, and various bodies. So the transjudicial communication and dialogue should be encouraged in the decision of the Commission, especially in this very case. And for fair trial, is an issue that the various bodies have discussed. So I just felt that that should come in. But overall, like I mentioned, the decision contributes substantially to the African human rights jurisprudence in three major areas. Number one, on issues of striking out of communications and when to release. What are the requirements for releasing? What is the nature of affidavits to be submitted? In this case, the victim and the complainant submitted affidavits. And then what is the type of argument that the commission will accept to release the communication? So the decision actually addressed those. So the second one is in the area of calculation of reasonable time. And then the last one, which is the major part of the decision, is the right to fair trial. So I want to say that it's a very good decision and very well written. Thank you very much.
Thank you very much, Dr. Ayeni, for that intervention. I think we'll go back to Irene if you've got any brief remarks before we give the victim the last word, and we'll conclude from there. So Ms. Irene Mbengwe, if you've got any responses to some of the issues that have been raised by Dr. Ayeni, please, in 1 minute, and then we'll have the victim have the last word and conclude.
Okay, thank you very much, Chair of the panel. I would just like to comment on the issue of strikeout and relisting, and just to indicate that at the time when this communication was instituted before the Commission, we're dealing with the 2010 rules, which did not have any specific provision on strikeout and relisting. So it was just a practice directive. But in the new rules of procedure 2020, under Rule 124 sub 2, we now have that we now have a legal basis for strikeout and release. And I think one of the things that you have mentioned, which not specifically in that sense, but understood to be that we should have some kind of guidelines on releasing of communications and what the parties are required to submit to justify releasing of a communication that has already been struck out for want of diligent prosecution. And in terms of the you mentioned the issue of, what did you say again about the calculation of reasonable time? I think the Commission also is also aligning itself with other human rights bodies, where a minimum period is 6 months. But most of the time, the Commission calculates reasonable time based on the circumstances of the case. So we have established guidelines and principles on various communications where we go by case basis, and it's mostly depending on the complexity of the case, the nature of the violations alleged, and the overall efficiency of the proceedings. So in summary, we look at the complexity of the case, the procedural steps that were taken by the parties, and in order to justify why the complaint or the communication came before the Commission with a period of time. So as you can see, there's no consistency in that sense. We have 6 months, 18 months, 22 months, but sometimes you might even have 22 months, but it's still admissible based on the compelling reasons that have been provided by the complainant. And then on the issue of, I think, fair trial, well, I guess the communication speaks for itself. The Commission did go deep into analyzing the issues of fair trial and underline the fact that fair trial and impartial adjudication to the extent of judges to ensure that judges make decisions without fear of retribution of favoritism. I think that really came out of the decision. And the Commission also noted that the fundamental human rights guaranteed individuals' entitlement to a fair and impartial process when their rights, liberties, or interests are at stake. So, and it also relied on its former jurisprudence on Communication 251, Lawyers for Human Rights versus Swaziland, where the Commission indeed held that fair trial guarantees and must be safeguarded for victims. So I think in that sense, like you said, the Commission in this communication really brought the issues of independence of judicial officers and the right to fair trial, generally the right to fair trial, and I think it's very explicit in this communication. Thank you very much.
But thank you very much, Irene, for the intervention. I see Abiola has some interventions as well.
Thank you very much, Mr. Moderator. Just to complement my colleague Irene and what she said, I'd like to add to three specific issues. The issue of the strikeout and the timeline within which it takes place. The issue of computation of reasonable time for bringing cases before the Commission and the timeline for finalization of cases. And the very interesting proposal to do an analysis of a comparative analysis of how this plays out in the three human rights bodies. On the issue of a strikeout, as my colleague mentioned, it was initially a practice directive, and it only manifested in the 2020 rules as an explicit provision. But it was introduced because it added when we talk about the Commission having 200, 300 pending cases, it doesn't necessarily mean that there are cases that have full filings. So we also have cases where complainants come, they file, and then they take off. So they add to the data. And the Commission found it expedient at some point to knock off the cases that were not being diligently prosecuted so that it would be clear about the cases that were actually duly before it for finalization. So that was how this was introduced. And the beauty of the Commission, or one of the beauties of the Commission, is the flexibility that it employs in relation to procedures, matters that are brought before it in different contexts. And initially, before the 2020 rules, the Commission would be amenable to listening to a party, even if a case had been, even if the case had been pending, let's say for like 2 or 3 years. And initially, the Commission then had directed the Secretariat to send last warnings to those complainants. So if we sent warnings and then they came back and they gave reasons, then the Commission will be open to still receiving the submissions. But now, under the 2020 rules, it's clear you are entitled to two extensions. The first one for 30 days and then the second one, and your request for extension has to come within your initial timeline. So if you were supposed to submit on 30 September and then you come to request for an extension on the 10th of October, the time has already run out. So that's one. Then the second issue in relation to the timeline for computation of a reasonable time. Again, as my colleague has indicated, the Commission's flexibility is grounded in the realities of the African continent. We can't compare ourselves with some other parts of the world where technology, the justice system, the structures and all would make it possible for justice to actually be dispensed within 6 months. And this is why the Commission has been flexible over the years. But since the case of Majuro and Zimbabwe, the Commission has also fairly standardized in that it takes 6 months as a threshold. And after that, you have to explain why you are just coming. So there's some sort of standardization, but then the flexibility is still there to accommodate the context within which access to justice is usually being sought by many complainants on the continent. And then on the last issue of the timeline for finalization of cases before the Commission, it's linked to the first point that I made. If we have 200 cases pending, for instance, those cases are not just sitting there, they're constantly being administered, updates provided to parties, filings received, sometimes contestations in between that you have to deal with. So they are constantly being processed, and it's still the same lawyers who are working on all of this. So definitely the bulk of cases before the Commission contributes to the availability of time for actually drafting final decisions, and the fact that there are many other responsibilities in between a lawyer could start drafting and then you have to go on a promotion mission and all of those things that are happening in between. So it's a combination of many factors. So I just wanted to say that. Thank you.
Thank you very much, Madam Abiola, for your intervention. I think I will give the last word to the victim for his concluding remarks, and then I will yield to the next case discussion.
Well, thank you. Thank you very much. On another light note, there is a vehicle in Namibia. It's the only one. Its registration number is 44413NA. And that is my vehicle. I'm always asked, what does this number mean? But it's the number of my communication, 444 of 2013. For me, I think the punchline in this whole judgment is to be found at paragraph 188. If I may just read it out, it's not long. Judicial independence refers to the ability of courts and judges to perform their duties free of influence or control by other actors. Whereas the notion judicial independence is more commonly understood from the perspective of the principle of separation of powers, judicial independence is equally impeded if judges have reason to fear disciplinary or other consequences due to their exercise of judicial functions, end of quote. And one thing that was emphatically highlighted was the decisional independence of judges, that judges cannot be told what words to use in judgments, and that if you use certain words, you might fall foul of disciplinary proceedings. So for me, I think this was the main thing. And I was asked, for instance, by the Chief Justice of Lesotho to give him a copy of this decision because he wanted to circulate it amongst his judges. And I'm also aware that at the University of Swaziland, they were writing their examinations, there was a case which was based on this very communication. So I think the work that the commission is doing is not in vain. This has been a victory, not just for me, but judges in the performance of their duties. The victim ends here. Thank you.
Well, thank you very much, our victim, for rounding this up nicely. And I would like to thank the panel for your interventions, and to Madam Abiola and our colleague from the Commission for intervening as well. And thank you to the audience for being a cooperative audience. And I will now hand over to the next panel. Thank you.
Good afternoon, everybody. I know you all thought you got rid of me already on Monday, but I'm back. If we could just call our panelists for our second session for today. The panelists for the applicant is Ms. Deborah Inyakabi and Ms. Ledia Kembabazi, who will be joining me in this discussion. And our ACHPR representative will be the Honorable Dr. Ogana. Okay, so I think just in the interest of time, we will just go right ahead. We do have about an hour allocated for the session, but I do know that it's been quite a long and packed day, so we will try to keep our submissions as brief as possible. So the way that I would like to structure this case discussion is, as the moderator, I will discuss the brief facts of the case and give you a bit of background to the actual case. And then I will be handing over to Ms. Deborah, who will be discussing the case from the perspective of the applicant. Thereafter, I will be handing over to the Honorable Dr. Ogana. who will be the ACHPR representative in the case. And then finally, I'll be handing over to Ms. Lydia, who will be discussing the case more generally and offering her remarks on this particular case. Okay, so the case is the case of Equality Now and the Ethiopian Women Lawyers Association versus the Federal Republic of Ethiopia. So just very briefly, I'll be providing some context on the case. So the complainant in the case was Ms. Negash, who was 13 years old when she was abducted for the first time by several men, and she was raped by Abaru Gemma Negusi, the accused. She was rescued by the police, and the accused was subsequently arrested. Evidence of rape was documented in a medical report. However, the accused was released on bail. Shortly after his release, the complainant was abducted and raped again. She was held captive in the home of the accused's brother and was forced to sign a marriage contract. After enduring a month of detention and suffering multiple acts of rape, the complainant escaped. She reported what had happened, and the complainant and the accused and his accomplices were arrested again. The accused was then sentenced to 10 years imprisonment without parole. The other accomplices were convicted of abduction and faced 8 years of imprisonment. Following their second arrest and conviction, the accused and his accomplices filed an appeal. At this point, the prosecutor that was assigned to the case appeared to sympathize with the men, despite his duty to present her case against them. During the appeal, the prosecutor stated that a woman could not be raped unless she was a virgin. Throughout the proceedings, it was clear that the prosecutor generally supported the acquittal of the accused and his accomplices, although at one point he did suggest that there should be a retrial of 2 of the accused. At the end of the trial, the bias of the other officials within the RC Zonal High Court became clear. The presiding judge decided to overturn all of the convictions, disregarding the prosecutor's suggestion that at least 2 of the men's cases could be retried. This is because the judge held that the evidence presented suggested that the complainant had in fact consented to the acts that were committed against her, and therefore no crime could have possibly taken place. In delivering his decision, the judge also went further to declare that no one would rape a woman who was not a virgin. Later evaluation of this decision would reveal that no clear evidence was offered to support this conclusion or for the High Court's decision to overturn the convictions. The complainant's lawyers then submitted 2 appeals against the decision of the RC Zonal High Court to no effect. At this point, with all of the domestic remedies available to the complainant exhausted, Equality Now and the Ethiopian Women Lawyers Association took her case to the African Commission on Human and People's Rights. I will end on this note. Throughout a 15-year pursuit of justice, the complainant endured a multitude of threats and was forced to seek asylum in a different country. I'll now hand over to Deborah, who will now discuss the case from the applicant's perspective, as well as the submissions that were made and the relief that was sought.
Thank you very much, Chairperson. My name is Deborah Nyokabi. It's a pleasure to be here once again. Unfortunately, I can't do justice as the previous victim, who was a direct victim, as well as the applicants who are Equality Now, but they could not be here. So I was requested to step in, and I hope I will fill those big shoes. Yeah, nevertheless, I think what the moderator has highlighted is that after all that happened, the Ethiopian Women Lawyers Association, as well as Equality Now, took up this case and filed a complaint before the African Commission on behalf of the victim in May 2007. And in the complaint, they alleged violations of various provisions of the African Charter, being Article 3, which is equality before the law and equal protection of the law, right to life and integrity of the person, Article 4, Article 5, inherent dignity and freedom from exploitation and degradation, particularly slavery, slave trade, torture, cruel, inhuman or degrading treatment, liberty of and security of the person, Article 18.3, elimination of every discrimination against women and the protection of the rights of the woman and the child. And this particular application was very strategic since it was also meant to have the broad impact of lobbying for better legal protections in the Ethiopian criminal code, which was also undergoing revisions at the time that the case was being presented before the African Commission. Order sought was for the government of Ethiopia to ensure equal protection of the law and an end to discrimination for girls subjected to abduction and rape in Ethiopia, mandatory comprehensive training of all law enforcement officials, including all levels of the judiciary, on the law against rape in Ethiopia, and to take appropriate remedial action in this particular case. Then award of compensation to the applicant for the violation, to the victim for the violations she had endured, and then a declaration that states failure to provide equal protection was contrary to the provisions of the African Charter that I had just cited, as well as to refile charges against the respondent in that matter who had raped and abducted the victim. So this case raises an interesting aspect that was discussed also in the previous case, being the proposal on amicable settlement. So 1 year after the case was filed in May 2008, the Ethiopian government proposed to go through an amicable settlement procedure before the commission. And during verbal discussions in November 2008, in the presence of the Secretariat of the Commission, the government of Ethiopia promised to take disciplinary action against the prosecutor and the judge. They also promised to give the victim a job in the field, in the law field, in the Regional State Justice Bureau, as well as to provide a house as part of the compensation. Just the other year, in May 2009, the government reported back to the African Commission that it had offered Weneshet, who is the victim, a job in the government housing agency as a financial ledge keeper. First, this is where the government doesn't keep its promise. It was meant to give her, it had undertaken to give her a job in the law field, yet now they were giving her a job in the housing agency, and that job didn't fit her qualifications. Neither did it meet the promise they had extended to her. Additionally, they gave her a house, but on condition that she would pay for it in full. Yet, as part of the settlement, amicable settlement, they had provided to give her a house as part of the compensation without any charges. Just to add salt to injury, later on, she was informed that she had actually been dismissed from the job that she had been given that didn't even fit her qualifications. So 2 years after the amicable settlement, which didn't take place as agreed, Equality Now went back to the African Commission saying that 2 years were a lot of time, and sought a declaration that the case be declared admissible, and now the procedure for justice and redress to be instituted. So in its decision, the commission actually held that the communication was admissible, as far as the complainant had exhausted local remedies, since, as explained, they had gone through all levels of courts in Ethiopia, as well as the government of Ethiopia had not acted in good faith in relation to the amicable settlement that had been proposed. Consequently, the commission proceeded to declare that the state had violated Article 3, 4, 5, 6, and 7(1) of the Charter, and the commission directed the government of Ethiopia to pay Ms. Weneshet, the victim, compensation to the equivalent of US dollars 150,000 for the non-material damages she had suffered as a result of the violations. The state also was urged to adopt and implement measures to specifically deal with marriage by abduction and rape, monitor instances of marriage by abduction and rape, and diligently prosecute and sanction offenders. Additionally, the respondent state was directed to continue training judicial officers on specific human rights themes, including on handling cases of violence against women. The state was also urged to report back to the commission within 180 days on the measures adopted to implement the above recommendations, as well as include in its next periodic report yearly statistics on the prevalence of marriages by abduction and rape, cases of successful prosecutions, and challenges faced, if any. So how does the implementation outlook look as we speak? First, as there has been highlighted, Ms. Weneshet had to flee the country and seek asylum, and consequently, up to this day, she has not yet been paid the 150,000 that was directed as compensation for non-material damage. The other issue that arises in this case that had been discussed in the Justice Masuku case is the overly long duration of this matter. The African Commission was seized of the matter in 2007, but the final decision as to compensation and all other aspects on the merit was rendered in 2020. That is a 13-year long wait. By the time the case, the African Commission was seized of the case, Ms. Weneshet was 13 years or so. So 13 years later, she's in her 20s, approaching her 30s. There was also now the issue that arose of lack of good faith in the amicable settlement process. We see the government actually offering to go through the amicable settlement process and making certain promises, like giving her a job in the legal sector for which she was qualified and giving her a house. Then they turned back and actually gave her a job for which she was not qualified, didn't give her a house on condition that she had to pay for it, and actually then proceeded also to fire her. So this aspect actually, I think, spoke to streamlining guidelines on the amicable settlement process. And I think it's quite encouraging that now Rule 112(3)(c) of the 2020 Rules of the Procedure actually details the amicable settlement process to even include an MOU that is signed and presented to the Commission to be adopted as a decision of the Commission. So this is likely to now make cases involving amicable settlement proceed more expeditiously and actually for parties to act in good faith. I think the other issue that arises is actually the pressure on the applicant and her lawyers. First, as we've heard, the applicant has had to flee the country. Similarly, here there were two representatives, two sets of counsel. One was the domestic one, being the Ethiopian Women Lawyers Association, and now Equality Now, which is a regional / international NGO. And what we see is actually there was also a lot of pressure on the Ethiopian Women Lawyers Association. Their offices were closed, their accounts were frozen, and actually the executive director had to leave the country. Then after that, it's like the government sat and thought, oh, we cannot reach out to Equality Now, but we can reach out to Ethiopian Women Lawyers Association, because at some point the victim wrote to the African Commission to tell them that the Ethiopian Women's Lawyers Association was no longer her counsel and only Equality Now would be her counsel. But the government of Ethiopia kept insisting in its responses before the commission that it's the Ethiopian Women Lawyers Association that was still the counsel of the victim, and that the Ethiopian Women Lawyers Association had actually seen and witnessed all these aspects of the amicable settlement, including presenting a title to the victim who was out of the country. So it was not realistic. So there was a lot of pressure on the victim herself, on the Ethiopian Women Lawyers Association, and maybe Equality Now, if they were here, they would speak to also if they experience any pressure. But then also this speaks to the importance of strategic partnerships in litigation, particularly in states where there's a democratic deficit. It's very important for local CSOs when filing cases before the African Commission or before other regional mechanisms to partner with regional and international organizations that may actually be able to counter the pressure that may be mounted by the government. A positive outcome of this is actually that the government of Ethiopia took positive legislative and other measures towards revising the criminal code and the family law code, and now there are greater protections for women and girls in these laws. So we see at the micro level, the applicant herself has not been able to gain justice, but at the macro level, there's justice for the girls and women of Ethiopia. And I think this speaks to the broader aspects of why we engage in strategic litigation. I'd like to stop my submission at that and give the floor back to the moderator.
Thank you so much for that, Deborah, and for your take on this, especially in drawing parallels between our victim, Justice Masuku's case as well. I think we can see a lot of similarities in how things were addressed, and especially with regards to the relief that is handed down, but really the implementation of that and how that works on a more domestic level. So I will now hand over to our Honorable Dr. Ogana, who can address us.
Thank you very much, Madam Moderator, for the floor. this is a very hectic case. You know, it is a case that when you look at it, it brings out all the issues that when we are fighting for women's rights and going all the way fighting for CEDAW, fighting for the Maputo Protocol, and our governments ratifying these instruments. And we're going back very happy and clapping that our governments have ratified this and they have endorsed that. Only when it happens, then the same government has to struggle, because from the local court to the high court to the Supreme Court, patriarchy is well seated in the room. And so I want to start with the context and say that this case tells us that it's not enough for our governments to just ratify conventions, like ratify the Charter and Maputo. If you look at the Charter, Article 18.3, governments committed to protect women and girls from discrimination. If you look at Maputo, Article 3.4, is protection from all forms of violence, protecting women and girls from all forms of violence. Article 4, 2A and B of Maputo also protects not just protecting women from violence, but also from sexual violence. Ethiopia has ratified all this. Articles 3.4, C, D, E, F, and I, the state obligation to protect and place measures to prevent, punishment, and guarantee remedies is there. Article 5D of Maputo, the state protects, confirms that it will protect women from harmful practices. So when you look at this case, for sure, it's not written, but this is a classic case of early marriage. Dowry has been paid somewhere. This is not coming in court, but you can see the way the Mr. Aberu is taken to, he abducts the girl first, takes her home, he's taken to court, then he's freed, then he goes and adopts her again. If you look at the background, if somebody steps back, you'll find negotiation of dowry has been done long before, and the women rights of activists are fighting a culture that is already entrenched. So this is really, and actually at the Supreme Court, you don't see the government or the judges feeling guilty because there's patriarchy underlying all this behavior. So, so the question to our government, and I'm happy that Ethiopia has tried to, towards the end, Ethiopia learns from this case, is that they have signed all and ratified all the protocols, but back at home, they have not really handled the issue of early marriage. It goes on every day in rural Africa. They have not put in place enough sensitization for communities to know, every girl below 18 is a child, and you cannot go and force her to not, sign contracts of marriage. You cannot force her. And actually, she's supposed to be in school. These are the issues we are talking about. So I think you can see the government struggling, trying to look good, going to say, oh, we are going to do an amicable settlement. And then, yes, 2 years later, the government, because everybody there is being hit by patriarchy and the culture. The government now cannot even explain why it says it will do this and then it does another thing. So this is the first thing that comes out of this case. The second thing that comes out of this case, actually, I've talked about the context and the underlying context, is the vulnerability. Justice talked about somebody being called a victim. These words, we in the women movement struggled with these words for a very long time. And by the time we called ourselves victims, it's because at the end of the road, you started as a woman, you find yourself actually now you're so vulnerable, you don't even know your name. So when people call you victim, you accept. When people call you something else, you accept. What we are saying is when we insist under Article 56 that victims must exhaust the legal remedies, this is a long process. People suffer during this thing we call exhaustion of local remedies. It takes a long time. Lawyers are involved. It is very expensive. And a lot of people just give up. So I want to say that just this Article 56, we at the commission sometimes when a case comes, we look at each of them because you're supposed to fulfill all them in entirety. But there are cases where you can look and see, no. We can say, like the commission did say, Article 56(5) may not have been exhausted the way it should be word by word, but just the sheer struggle of these lawyers going to the zonal court, then going to the high court, then going to Supreme Court, and every time they're being met by surprises, it means that people suffer in the process, and we must be very aware of this. By the time people get to the commission, by the time people get to Arusha, by the time people get to the children's court, people have suffered. We must take this into consideration, and this is one of the things I thought we should bring up. What causes the delays? What caused the delay in this particular case? If you look at, I went through the whole case, and you can see from day one, commission is seized with the matter. The commission does everything to try and fast track this case. But at some point, things stall. And then government says, oh, we are going to settle this matter. Then it doesn't. Then the commission even sends a commissioner to go and be the intermediary to facilitate. So it's not that work was not done. But, when now you go to the, to the admissibility, and paragraphs are there, you see the amount of work that goes into the initial submissions, and then the government submissions, and then the victims claims submits again. This is time spent. Then when you go to the merit, same thing happens. The lawyers of the claimant submits, then the government submits, and then there's another right of reply. So this whole thing is so exhaustive. And so delays happen. And what happens? If, for example, this girl was 13. By 2015, this girl is 18. If she did not continue going to school, if she actually had succumbed to the marriage, that would have been the end of her education. But supposing she decided to continue with school, she is going to school having already been violated. And so our schools are not even our teachers are not even trained to deal with a child like this who had been married and comes back to school to continue with school. And that's why when we have the back to school policy for girls who have had children, you find that some of the biggest challenges we have is with the women teachers sometimes, because they're trying to understand this thing of your mother, then you are a student, because they themselves may have gone through the same challenges. So we find it's very difficult to think of this girl who was married at 13 and ends up not being married, and then she has to go to school. So these are lifetime repercussions which accompany her throughout her life. And so I think these are things that we cannot just ignore. Let's now talk about the reparations. In fact, before we go to reparations, let's talk about the Ethiopian legal, the women lawyers. The women lawyers started with psyche, with energy to fight. But at the end, their offices are being closed, their bank accounts are being frozen. You cannot fight a government. It's very difficult. So they also now run away or they go to exile. This is what we are talking about. And that is why we in the African Commission, I think the fact that it is human and people's rights speaks to some of these things, because it's not that they do not want to continue with the case, but things have happened around which make it impossible for them to continue. So we are looking for an environment where defenders of human rights, defenders of women's rights also are protected. Because for sure, FIDA, this is FIDA Ethiopia, they're not protected, they're exposed as well. And without this environment where people are able to engage in a safe environment, it is very difficult to defend even the victims. Lastly, I wanted to talk about the reparations, and that is the figures. When the government says, oh, we all say $250 is a lot of money, it takes me back to yesterday where we said, if it was a company, a private company that had gone to court and asked for $250,000, there would be nothing wrong with that, because, it's okay. But this is a child whose life has been damaged at the beginning of her life. She may have to start all over again. So what makes 250 so much money, so much money? Eventually we go ahead and we award 150. Even that $150 has not been paid. So really, this now becomes a very serious matter. And if there is anywhere where we need to put our energy, is to make sure that when there are reparations, when decisions are made and victims need to be compensated, this compensation should be done. Maybe we should think of a compensation fund. Houses, forums like this should come up with ideas that can help us move forward, because we are here to think about victims. So if governments do not make this money available, why don't we set up a fund which at least can pay some percent to this out of the, of the decision? If it is 150, at least this fund can pay some little money to make these people continue with life while we are waiting for government to come through. So in conclusion, I just wanted to say that I read the documents thoroughly. I agree with the process was really very, very thorough, but it hasn't given our girl anything. So really, we must not get involved in a process where even the victim, after we give them rights, they go home empty-handed. And so my conclusion is, let us come up with a way of making sure that where decisions involve reparations, at least the victim gets something to take home. I thank you.
Thank you so much for that, Dr. Organa. I think there were some very good submissions that were in there. And if I could just canvas some of those and just summarize it. I think what was very important was, addressing how pervasive patriarchy is in our societies, especially on a domestic level, and how we have states who do ratify multiple protocols which are put into place to protect women and girls. But the reality on the ground is often a very stark contrast to that. And particularly when it comes to the aspect of the exhaustion of domestic and local remedies, how that can act as a very big barrier to a lot of women, especially getting their justice and being subject to processes like our complainant in this particular case. And that's something that definitely needs to be addressed, and we need to find a way to perhaps, expedite that. And then I think also the aspect of the plight of NGOs, and especially local NGOs that are on the ground, and the need for us to have measures that are put into place for the protection of such human rights defenders. These cases take a very long time, and not all NGOs are in a position to fight the good fight up until the very end. And so measures that are put into place in order to protect human rights defenders on the ground is very important. And I think of of great importance is particularly the aspect of reparations, which the Honorable Dr. Ogana touched on, and how, the Commission can make various rulings on the amounts of compensation that needs to be paid. But just like in this case, it's taken a very long time and our complainant has not been paid that money. And so the creation of sort of a fund which would contribute a certain percentage towards the payment of the compensation in the interim, I think that that's a very interesting idea. But I also think this might be just a different perspective, that this might allow for situations where states then take much longer to actually pay the compensation if we have a fund which is covering those kind of payments in the interim. And so that could be a great idea, but it could also be subject to abuse. So I think that that would be something for everyone to think about and navigate as well. But for now, I will hand over to Ms. Lydia, who will be just discussing the case very generally and bringing up some interesting points for us to consider. Thank you.
Thank you very much, Tamika, for that. And I would like to thank my panelists as well for their input on the case. It's sad, really, that just celebrating the anniversary of the Maputo Protocol recently, we are still having this discussion on women and girls' rights, particularly that we have such a case with an important consideration of an intersection of women and girls' rights relevant to the abolition of traditional practices that affect children and women's health rights. I would like to commend the Commission, of course, and reiterate their due diligence on the standard they set regarding violence against women and their obligations to prevent, protect, punish, and provide reparations in such situations. And I think that the Commission's categorizing and characterizing forced marriage and abduction and rape as one of the most repugnant traditional practices emphasizes that though rape was not listed under Article 5 of the Charter, it is a grave violation resulting in pain, humiliation, inhuman and degrading treatment. And we commend the Commission for taking steps to ensure that the government of Ethiopia eliminates such harmful practices. The Commission's emphasis on state responsibility also to prevent such violations was a significant victory. And additionally, the fact that the Commission founded monetary compensation for non-material damages should be determined as a matter of impression, since you take into consideration all circumstances into account. The Commission's award departs from the earlier focus on declaratory relief and affirms the right to an effective remedy, not just a remedy, but one that is effective. However, I will still go back onto the issue of the Commission's not finding discrimination against women in the claim of the case. I believe was just a narrow consideration of the situation against violence, on the situation of violence against women, because there can never be a comparative situation. Like they mentioned that there was no comparative comparator, if I may call it, to see that boys or girls suffered equally the same or more girls suffered the same. So I think that the Commission in this case really missed an opportunity for finding a progressive law, despite the fact that comparative jurisprudence was not there, but take into consideration the vulnerability of women and girls in this particular context, and no need to have had a comparative need to see whether boys suffered the same situation as the girls. Still on the same case, I think that the Commission found that this case really sets a legal precedent and affirms the rights of girls and the responsibility of states to take positive action to uphold those rights, specifically involving rape and abduction. In this case, of course, there's very many opportunities that can come in terms of training, judicial officers promptly prosecuting perpetrators, noting that this took a long time and most of them got away scot-free until they were prosecuted again. We would like to thank, of course, the pressure from Equality Now, FIDA Ethiopia, for having put pressure and the law was changed. Now, to comment on what the panelists discussed, starting with what the commissioner mentioned on compensation fund. This, I believe, really goes back to what I talked about shortly before we went for lunch on implementation, follow-up. And I would like to use an example we had with the Nubian cases in Kenya, where we had a discussion with the government, because most governments have priorities and different priorities, and paying off compensation is the least of their worries. So without having a particularly focal point person who can follow that up, or even having to go down and come up with a payment plan, at times the government may not budget for $150,000 for that financial year. However, they could give 50,000 in the beginning and have a payment plan. So dialogues in terms of how rewards are given and how recommendations and decisions are implemented goes back into what I talked about, an implementation working group and a good network on the ground that can ensure follow-up of the same. Brings me to the point of pressure on the lawyers, risk, and I concur with strategic partnerships on the ground to continue to protect human rights defenders, but as well as follow up on these case discussions. And as well as I believe, and this is something that I am putting to the discussions and to open to the group today, to put into consideration when you're making those legal briefs, when you're making these complaints to the commission or to any other regional body, to sit down always and have an advocacy plan, a risk strategy plan, because these are things that you put into consideration that will mitigate issues that we have seen happen in terms of human rights defenders, who is going to be speaking specifically for this case, who, in case of any retaliation, what protection mechanisms are put into consideration in case a victim needs to have protection. So some of these, depending on the sensitivity of the issue and whether such a thing has ever happened before, if you have something to learn from and see if it has happened, well and good. But even if it has been there before, situations are different and every case should be taken into context to discuss the same. Still on the same, I think that I would commend the government of Ethiopia, though, for having passed the law in their penal code, much as the case facts can show a lot of impunity and patriarchy, which I think I call upon all of us here to take into consideration. I think not only for this case, but other situations. I believe that in this case, rape can be the worst nightmare that can happen to anybody. So for a government to be complacent and have to deal with this situation with so much impunity goes to show how much awareness and how much discussions we still need to have against traditional practices. The Gambia is on fire, even as we speak right now, on the issue of FGM. And we are just celebrating Maputo Protocol anniversary, but unfortunately it's like we're still living in 1980, or even 80 was good. It's like we are retrogressing, really. So I believe that this is a case that implementation can be done and we can work on the same. I believe there are very many women's rights organizations, even those that are not women's rights, but believe in the rule of law, access to justice, human rights protection and promotion, that can work to ensure that this case is implemented to its full, to ensure that justice is not only done, but seen to be done. I thank you.
Thank you so much for that, Lydia. You had some very interesting points there as well. Just in the interest of time, I'd just like to open up the floor now to any questions or potential points that anyone would like to raise. And I also invite the panelists as well to the opportunity for them to offer any additional comments as well. So we'll take maybe 2 or 3 questions and or comments. Okay, it doesn't seem like anybody has any additional comments. Is there anyone online that has any questions or comments? I do see that there is something on the chat. No questions online.
It's a question online. It reads, it's a comment, sorry, from Joseph. If judicial officers fail to deliver justice to a victim of human rights abuse, like for the case of the Ethiopian Women's Lawyers Association, a judicial officer, excuse me, I can't see, Officer B, I can't make up what this person is saying. All right, I'm going to try. B, deal with personally and monthly net pay attached to compensation to compensate a victim to reducing judicial process as presented by a panelist. It's not very clear. Okay, so from the very beginning it says, I understand the submission well. On human rights prosecution, if the government is hard to prosecute, individual perpetrators may be best to prosecute on vicarious liability. Section 14.1 of the Human Rights Enforcement Act 2019 for Uganda may be a good, and it states loss of immunity from prosecution. Subsection 1, immunity shall not be a defense to proceedings commenced under this act. If judicial officers fail to deliver justice to a victim of human rights abuse, like for the case of Ethiopian Women's Lawyers Association, a judicial officer be deal with personally and monthly net pay attached to compensate a victim to reduce long judicial process as presented by a panelist. Were you able to get that? Does it make sense?
I think it was a bit difficult to follow. I think perhaps could we ask if that particular participant online is able to come on and maybe clarify the question?
OP or Joseph, are you online to clarify your question or comment? Yeah, it is a bit long-winded.
Okay, I see we have a comment from Justice Masuku.
What I understand the question to say is that if there is a violation and a judicial officer is party to that, it would seem that the law does not give immunity to the judicial officer. He can be personally censured for failing to carry out his obligations, and that might go to the compensation of the victim. That's how I understand it. I might be wrong.
Okay, I think having regard. Okay, Joseph, I see that you are online.
Yes, it has been clarified that way because it's happening here in Uganda. You do anything, they prosecute you personally. So it's deterring them from any human rights abuse here. So the gentleman has clarified that exactly. So it may reduce some workload from the High Court or somewhere. Thank you.
Okay, perfect. I think we've got the clarification on that. So I'll open that up to our panelists. Is there anyone that would like to address that?
Thank you. Joseph, I am glad you're from Uganda, which I am as well. I would say it would be very good to add that to the compensation maybe also of victims like you mentioned. And when we were passing the anti-torture law in the country, we campaigned because most people would hide behind the government, and it was always the state that was responsible to pay out compensation to victims of torture. And it was such a huge burden because everybody was hiding behind the state. But now, if individuals were identified in the anti-torture law that was passed in 2012, if individuals were identified to have carried out the torture, their salaries could go a long way also in compensating the victims of torture. And for the longest time, torture, according to the Uganda Human Rights Commission, always had the highest number of violations each year as the most violated human right. But after passing into law of that law, it reduced. It was number 2. So I think it also has a deterrent effect to that. So I could call upon my other panelists to give their.
Yes, Justice Masuku.
Well, I will just make a comparison. We have had cases, and I have been involved in a few. They were not of the kind that we are dealing with, but it was issues of police brutality and torture. So in one of the cases, because when it comes to compensation, you might find that if you say the official must pay the compensation, you find that his means might not be enough. So we've had a situation where the damages are paid by government, but when it comes to costs, the courts have held that the officers involved must personally pay the costs, and the cost would be sometimes at a punitive scale, so that they feel the pinch personally of what they do, because otherwise it only becomes an issue of the government, and those people will continue, doing the same thing again, knowing that they will not be personally held liable for what they do. And at the end of the day, it becomes everybody, including the judge who might be trying the matter, because he or she is a taxpayer. At the end of the day, you might be sitting on a matter, but you'll be paying, the costs or even the damages of a person that appeared before him. So that where there is a personal price that people pay, it might to some extent ameliorate, the extent at which some of these atrocities are committed. Thank you, Madam Moderator.
Thank you so much. Do we have any further additional comments from our panelists before we conclude? Okay, then I think on that note that we can conclude this case discussion. I would like to thank all of our panelists for their interactions and their participation in the session. I think it has been very engaging. So yes, thank you so much. And I will now be handing over. I don't see Felucia anywhere. I know that our next item on the program is the closing by Lloyd. I think perhaps we will hand over to Felucia now, who will be addressing you quickly before handing over to Lloyd. I thank you so much for your time and attention. Okay, I've just been advised that we'll just be handing over to Lloyd to do the closing and the vote of thanks.
Thank you very much, Chair and Moderator. So good afternoon to all of us. I think we've had a very successful conference on implementation. And this is the third one after Dakar and Zanzibar. Judging by the levels of participation from day one until today, I think, the people who were supposed to be in this room were here. And because everybody participated actively and everyone was attentive, and there were so many recommendations and suggestions on the way forward, and such that I think that the African Commission itself and academia, practitioners, experts, and scholars in the room will have something to reflect on, and also to see how we can implement some of the suggestions and recommendations that came out of the deliberations. I think what was also clear is that we all want the same thing, the protection of human rights of the most vulnerable people on the continent, including, I didn't know that judges could also be vulnerable. So, so clearly, I mean, if judges can be victims of human rights violations, what more the most vulnerable, marginalized, and indigent members of our society. It means that we need a commission that is very strong, that is very effective in terms of its operations, in terms of its ability to implement the decisions that it comes up with, and also being able to hold accountable both state and non-state actors who are, you know, at the forefront when it comes to human rights violations, or when it comes to their neglecting to live up to their obligations in terms of the African Charter and other relevant human rights instruments that have been adopted at the level of the African Union, but also at the United Nations level. I found the deliberations to be very robust, to be very engaging, very honest, and without emotion. That was the most important thing, which means that I think most of the suggestions and recommendations that came out are going to be implemented for the benefit of people of Africa, but also for the benefit of the Commission itself in terms of its efficiency and its effectiveness. So I just then want to thank everyone. I'll start with the Commission itself and say that as the Center for Human Rights, as civil society organizations here present, as academic institutions present here, and practitioners and scholars, we are here to support the Commission so that the work of the Commission will continue, and that the protection mandates and promotional mandate of the Commission will really be as effective as it was intended in terms of the African Charter. So my thanks will go to the chairperson and the Honorable Commissioner, Dr. Lita, the acting secretary, Madam Abiola, and members of the various human rights bodies that were present in the room, Pan-African Parliament, the Committee of Experts on the Rights and Welfare of Children, and the court as well, that was also represented. And all your interventions were critical for the success of this conference. I would also want to thank all the state representatives who were present to also share insights from the side of the state. And I just want to also just reiterate to state representatives that the center runs short courses, and those short courses, we actually give preference to state delegates as well as members from national human rights institutions. I would also want to thank all the academics that were here, you know, and the scholars and the experts in the various fields of human rights for really taking your time off from your busy schedules to attend this conference. Lastly, I want to thank the Center for Human Rights team. I really think that the support from across the units that I've witnessed here was really amazing. We had colleagues from the implementation unit, the children's rights unit, the communications unit, the trade and investment law program, human rights and democracy program, as well as the multidisciplinary and human rights program. So I think what I really want to say is that thank you so much for the teamwork. It's because of your teamwork that this conference has been a success. And then also just to mention and thank the leadership of the center, from Professor Franz Fillion, Professor Murungi here, and also for Lucio and Michael for leading the implementation units and the organization of this conference, and also choosing the right persons to be in the room today. And I would want to say to everyone, Ambakashle, au revoir, all the best as you go back to your respective stations, and we'll see you next time. To the Commission, we are going to be seeing you in Arusha A lot of civil society organizations have already been saying that they want to go to Arusha because it's the judicial capital of Africa. That's where the session of the commission is happening in next month and beginning of November. So we wish you a very successful session next month, and we will be there. And to everyone else, wish you safe journeys, safe trips back to your respective stations, and thank you so much. I wanted to check if my boss wanted to have a last word, but I'll hand over to Felusho for any logistical issues. Thank you very much.
Thanks, Lloyd. I was also waiting for my boss to officially close the conference. I think the conference has been closed officially. Just maybe to say that for our colleagues that we have to reimburse for your visa and other logistic payments, please just stay behind. We are trying to finalize that arrangement, and so we can get you to sign the necessary document for us, and we can also do the reimbursement as promised. Otherwise, I think that's all from my side, and maybe just to lend my voice to Lloyd to thank you all for making this conference a big success, and we hope to see you at other platforms, which I'm pretty sure we will be engaging over the course of the next years. Thank you very much. We can go now.